memanfaatkan kekuasaan dan mendahulukan
Our journey begins with the parties involved in
Judges and attorneys in open court.
IDB 2000 contract. This is a
Assalamualaikum to Sayus. My name is Rina binti Shahya and today I'm going to explain regarding the project of construction law and contract. So for this project, we are focusing on PWD Form 203A, PEM Contract 2018 with quantities and CIDB 2000, and we are going to compare those three COC and cases. So first is clause 33 deduction from money due to contractor. And for PEM is clause 27.6 value of contractor to pay nominated subcontractor. And for CIDB is clause 42.9 period of honoring certificate. These clauses collectively ensure financial integrity, timely payments, and accountability within the contractual relationship involved. Each serves a specific purpose within the contract framework. For example of the case is Dewey Construction Pty Ltd in liquidation versus Diethelm Industries. The, the thing held is upon liquidation, an insolvent company asset must be distributed among its creditors equally as per insolvency laws. Any contract by an insolvent company that deviates from this rule is contrary to public policy and must be disregarded by the liquidator. The court ruled in favor of the plaintiff, declaring that the government direct payment to subcontractor under Clause 20E will void against the liquidator and contractment insolvency laws. Next is Clause 34, which is regarding prime cost and provisional sum. All three clauses concern the determination of monies owed to the contractor in connection to prime cost or provisional sum. Clause 34 and 41 for CIDB contain identical rules addressing the deduction of prime cost of PC sum from the contract sum and the substitution of actual amounts owing to nominated subcontractor or supplier, while Clause 11.4 for PEM focus on the architect's responsibility in administering PC sum and provisional sum by issuing architect instruction. For the case is Midland Expressway Limited and Carillon Construction Limited. The Secretary of State awarded a commercial agreement to Midland for M6 Toll Road planning, building and management. A disagreement arose regarding payment for variation number 11 leading to arbitration. Men argue the judge lacked authority. The conclusion of this case is that the court rejected Mel's request for a declaration and injunction, affirming CAMBBA's right to proceed with education over the payment dispute. Next is Clause 35, which is regarding materials, goods, and workmanship. The clause focuses on ensuring quality in building projects, covering standard testing protocols, duties, taxes, ownership of material, and contractors' duty. Clause 14 for PEM emphasizes ownership and care, while Clause 15 for CIDB details quality assurance and control steps, including quality plan submission, sample provision, testing protocols, inspection requirements, and fault correction. For the case, it is regarding Murphy v. Brentwood District Council, 1991. In Murphy v. Brentwood District Council, the House of Lords ruled that the defendant local authority was not liable in negligence of damages suffered by the claimant due to defective footing of a house. The claimant had purchased the property but faced subsidence due to defects leading to the loss of property and claimant claims for damage. The court deemed it unacceptably wide to allow the claimant to recover damages for the property sales or repair costs. Next is also similar to the Clause 35 but is regarding inspection and testing of materials, goods, and equipment. All three clauses in COC in construction project regulation ensure that product, labors, and material meet quality control, testing, and inspection requirements. Clause 15 in CIDB provides general criteria, while Clause 36 for PWD and Clause 6 for PEM, which is material, goods, and workmanship, to conform to description, testing, and inspection, establish specific protocols for testing, inspection, and handling non-compliant work. For the case, it is Young and Martin Limited and McManus Chase Limited. The House of Lords heard counsel on the petition and appeal of Young and Martin Limited against McManus Chase Limited. The petitioner requests that the order of Her Majesty's Court of Appeal of June 23, 1967 be reviewed and reversed. The Lords Spiritual and Temporal in the Court of Parliament of Her Majesty the Queen assembled, and the petition and appeal were dismissed. The appellant were ordered to pay the costs incurred in the appeal, which were certified by the Clerk of Parliament. The case involved Lord Reid, Lord Pearce, Lord Upjohn, Lord Wilberforce, and Lord Pearson. Next is Clause 37 in PWD, which is constructional plan, equipment, vehicles, and machineries. Clause 37 focuses on importation, tax payment, custom clearance of building plans, equipment, vehicles, and machinery, while Clause 35 for PEM outline parties' right and obligation post-employment, while Clause 33 for CIDB covers construction equipment, temporary work, materials, and product. The case is Butler Machine 2 versus Excel Oil Corporation. The plaintiff offers £75,535 sterling Machine 2 delivery for 10 months with the buyer's term not including a price variation clause. The seller increased the price, but the buyer refused, claiming delay and interest costs. The court initially ordered the buyer to pay the increased cost, but the buyer appealed. The court found that the buyer's order was a counter-offer accepted by the seller, and the contract was completed without the price variation clause, allowing the seller to not increase the total cost. Next, I'm going to explain regarding the position of site. The contractor's site position is covered by three clauses, including timing and protocol. For Clause 38 in PWD, it outlines method for gaining possession, requirement for construction, and delay option. For Clause 21 in PEM, it provides times extension for contract termination, and while Clause 17.2 in CIDB focus on the contractor entitlement to site access before commencement date. For the case I took is Rapid Building Group versus Ewing Family Housing Association. The court ruled that the defendant's failure to give possession of a housing estate in West London was a breach of contract and applied Peake versus McKinney case to its law case. The court held that Clause 21 provided that the possession of the site should be given to the contractor, and EFHA breached this by failing to remove squatters. The employers can recover unliquidated damages if the contractor doesn't complete the works within a reasonable time. The Court of Appeal distinguished LRE versus Otto Simon Clark, which focused on the construction of Clause 21. So that's all for my part, and I'm going to hand it over to my friend Irina. Thank you.
Thank you, Serena, for your explanation from clause 33 until 38. My name is Serena Adlin, and today I'm going to talk about clause 39 until 44. So, for clause 39, completion of work. For PWD 203A, 39.1, subject to clause 38.3 and 41, the contractor shall complete the whole of the work on or before the date for completion as stated in the appendix, or such extended time as may be allowed under clause 43 hereof. 39.2, if the contractor consider that the work have achieved practical completion, the contractor shall notify the SO in writing to that effect. 39.3, within 14 days of receipt of such notice, the SO shall carry out testing or inspection of the work. For PEM 2018, the contractor shall, upon and subject to this condition, carry out and complete the work in accordance with the contract document and in compliance therewith provide materials, goods, and standard of workmanship of the quality and standard described in the contract document and or required by the architect in accordance with the provision of the contract. For CIDB 2000, when the contractor consider that the work have achieved completion sufficient to enable the successful completion of the test on completion, he may notify the superintending officer in writing to that effect. Within 14 days of receipt of such notice, the superintending officer shall carry out an inspection of the work and the the in, they carry out the test on completion prescribed by the contract. For cases that are related to completion of work, Mears versus cost plan. In Mears versus cost plan, Mears sought to challenge the certification of practical completion under an agreement for lease for blocks of student accommodation that were under construction. Mears were obligated to take a lease on practical completion being certified. So long as practical completion occurred before the contractual long stop date. Practical completion was not defined in the agreement for lease or the building contract. The agreement for lease prescribed certain floor areas for the room within the property, but much to Mia's dismay, the property was not constructed in accordance with those requirements. 56 of the room in the property were smaller than they should have been. Mears looked to avoid its obligation to take the lease, arguing that practical completion could not occur. At the very least, this judgment provide useful guidance for industry professionals considering whether practical completion has occurred. Next, Clause 40, damage for non-completion. So for comparison, all three of the contract have mentioned that if the contractor fails to complete the work by the completion date, SO and architect shall forthwith issue a certificate of non-completion to the contractor. The contractor shall pay or allow to the employer a sum calculated at the rate stated in the appendix as liquidated damages for the period from the completion date to the date of practical completion. For the case that related to this clause, Clyde Bank Engineering versus Don Jose Ramos. In the Clyde Bank Engineering and Shipbuilding versus Don Jose Ramos, the plaintiff, Clyde Bank Engineering, entered into a contract with the defendant, Don Jose, for the construction of a steam. The contract contained a clause specifying the date by which the ship was to be completed. The defendant argued that the plaintiff had not completed the construction by the agreed upon date, and as a result, the defendant rescinded the contract. The plaintiff claimed that time was not of the essence in the contract, and the delay did not give the defendant the right to rescind. In this case, the court found that the delay in completion did not have serious consequences for the defendant, and therefore the breach was not sufficient to give the defendant the right to rescind the contract. The judgment established the principle that the classification of terms in contract should be based on the practical effect of the breach rather than rigid labels, leading to development of the concept of innominate term in contract law. Next, clause 41, sectional completion. Comparison. PWD 203A, BAM and CIDB contract form have mentioned the same thing, that where different completion date for different section or part of the work are stated and identified in appendix or elsewhere in the contract document, and different and separate liquidated and ascertained damages are provided for each section or part of the work. The provision of this contract in regard to certificate, practical completion, delay and extension of time, liquidated ascertained damages, and defect liability period. For the case that related to this clause, University of Warwick versus Balfour Beatty Group. The University of Warwick contract Balfour Beatty Group under an amended JCT 2011 DNB to design and construct the National Automotive Innovation Centre. The work was split into four sections. Balfour Beatty took possession of each of these sections on the 20 April 2015. However, the date for completion specified for each section varies. Section until 1 until 3 were to be completed by April 2017, but Section 4 had a later completion date of July 2017. Warwick was entitled to recover liquidated and ascertained damage in circumstances where Balfour Beatty did not achieve practical completion, with different rates of LAD applied per section. On 2 May 2018, the adjudicator found in Balfour Beatty's favour, stating the practical completion could not be sectional because The only time that the center could be occupied and used was when all four sections had achieved practical completion. This was further supported by the ordinary and natural meaning of the word, namely the definition of property referring to the work alone, suggesting that it was not possible to achieve practical completion of any section in isolation from the other section. Next, clause 42, partial occupation taking over by government. For comparison, both PAM and CIDB contract form have mentioned the same thing, that within 14 days from the date of which the employer has taken possession of the occupied part, the architect OSO shall issue a certificate of partial completion. While for PWD 203A, contract form mentioned that within 7 days from the date on which the government shall have taken possession of the relevant part, the SO shall issue a certificate of partial. Case that related to this clause is Bramall and Ogden versus Sheffield City Council. In this case, Bramall was employed to build 123 houses comprised in 20 blocks. There was an entitlement to take partial possession, and Sheffield Council duly took possession of some of the house. It then claimed damages for houses that were laid. The partial possession clause provided that the LAD would be reduced to reflect the fact that some of the work had been taken over. But the problem was that the LAD had been expressed as £20 per week per house. The client wasn't taking over part of a house. It was taking over part of the works. And the works didn't just include houses but also garages and other common parts. As the damage were not expressed per section or for the works as a whole, the calculation couldn't work. The court affirmed the contractual provisions concerning extension of time and liquidated damages should be construed strictly against an employer. Next, clause 43, delay and extension of time. All three of the contract form have mentioned that upon it become reasonably apparent that the progress of the work is delayed, the contractor shall forthwith give written notice to the SO or architect as to the causes of delay and relevant information with supporting document enabling the said officer to form an opinion as to the cause and calculation of the length of the delay. But for PAM contract, the contractor shall give written notice to the contract his attention to claim for such extension of time together with an initial estimate of the extension of time he may require, supported with all particular of the cause of delay. Such notice must be given 28 days from the date of the ICAI or the commencement of the relevant event, whichever is earlier. Case that related to this clause is the KL EcoCity versus Tuxin Engineering. The KL EcoCity project was a major unified development which included a link bridge connecting to the project to Med Valley City. Tuxin Engineering was the main contractor for the project, and the original completion date was set on 2nd of June 2016. There were two applications for AOT by Tuxin which were granted extended completion date until 20 July 2016. Subsequently, the architect issued a certificate of non-completion, resulting in KL EcoCity imposing liquidated damages of 1,050,000 against Taksin. Taksin claimed that such conduct mean the architect has waived the requirement for the contractual condition precedent. However, the court held that waiver on the part of the architect would not exempt the contractor from its requirement to comply with the contractual condition precedent because the architect does not have the right to waive the contractual right on behalf of the employer unless the employer accept and or ratify the waiver. And lastly, clause 44, claim for loss and expenses. Both PWD 203 and CIDB contract form have mentioned that the contractor has incurred direct loss and all expenses beyond the reasonably contemplated and for which the contractor will not be reimbursed by a payment made under any other provision in this contract. Then the contractor shall within 30 days of the occurrence of such event or circumstances or instruction give notice in writing to the SO of his intention to claim for such direct loss or expenses together with an estimate of the amount of such loss and or expenses. For PEM contract, it mentioned that the contractor has incurred or is likely to incur loss and or expenses which could not be reimbursed by a payment made under any provision in the contract. The contractor may make a claim for such a loss or expenses provided. The contractor shall give written notice to the architect of his intention to claim for such a loss and or expenses together with an initial estimate duly supported with all necessary calculation. Such notice must be given within 28 days from the date of the CAI or of the occurrence of the matter referred to in clause 24.3, whichever is the earlier. Case that related to this clause is Sunisa Sdn Berhad versus Kerajaan Malaysia. The High Court in Sunisa Sdn Berhad versus Kerajaan Malaysia decided among other that clause 44.1 of the PWD contract 203A is a condition precedent for loss and expenses claim under the contract, and the failure to comply with the same would bar the contractor's claim. The High Court further held that this bar only applies to claims which are not within reasonable contemplation of the party. The Court of Appeal the Court of Appeal also considered that issue as to whether a contractor can maintain its loss and expenses claim after signing the certificate of final account and acknowledging that there is no further claim under the contract. And that's all from me. Now I'm going to hand over to my friend Zatu Fahna.
Thank you to my friend Nurina. Hi and Assalamualaikum. My name is Norzatul Fahana bin Zulkarnain. So today I will explain about clause 45 until 48. So clause 45 is about investigation by the government and other person in case of accident, failure or other event. So the comparison is PWD 203A typically governs contract for building project involving a government agency in Malaysia. While it may not explicitly outline procedures for investigation in case of accident or failures, it may reference relevant laws and regulation that dictate the responsibilities of the parties involved. So for the PEM 2000 is another standard form of contract used in Malaysia, particularly in building projects. Similar to PWD 203A, it may not explicitly address investigation but may incorporate clause related to dispute resolution and claims management. So for CIDB 2000, it specifically tolerate for construction projects in Malaysia and may include provisions addressing investigations and dispute resolution processes more comprehensively compared to PWD 203A and PEN 2000. So for the case, is Alcock versus Chief Constable of South Yorkshire at 1992. A joint action was brought by a Clock C and several other claimants against the head of the South Yorkshire Police. C and the other claimants all had relatives who were caught up in the Hillsborough Stadium disaster, in which 95 fans of Liverpool FC died in a crash due. It was later established to the negligence of the police in permitting too many supporters to crowd in one part of the stadium. The disaster was broadcast on live television, where several claimants alleged they had witnessed friends and relatives die. Others were present in the stadium or had heard about the events in other ways. All claimed damages for the physical harm they suffered as a result. The House of Lords were called upon to determine whether, for the purpose of establish liability in negligence, those who suffer purely physical harm from witnessing an event at which they are not physically present are sufficiently proximate for a duty to be owed, and thus can be said to be reasonably within the contemplation of the tortfeasor. So next is clause 46 is access for works etc. So the comparison PWD 203A may specify the obligations of the employer, usually a government agency, to provide the contractor with suitable access to the construction site. This could include ensuring that roads leading to the site are accessible and suitable for transporting materials and equipment. So for the PAM 2000, may detail the requirement for providing access to the construction site, such as ensuring that access roads are constructed or maintained in a suitable condition for construction traffic. For CIDB 2000 may outline the responsibilities of both the employer and the contractor regarding access to the construction site, including the provisions of access road, temporary facilities, and utilities necessary for construction activities. So for the cases, Levy versus Landgrich 1838. In this case, a landowner was held liable for obstructing a private right of way across his land. The court ruled that the landowner action constituted a trespass and awarded damage to the plaintiff for interference with their access rights. This case illustrates the legal principles and consideration surrounding access to property, right of way, and obligation of landowners or authorities to maintain access for works or other purpose. Next, we will go to clause 47 is subcontract or assignment. So for the comparison, within PWD 203A, provision regarding subcontracting are likely outlined, specifying the condition under which the main contractor may engage subcontractors to perform certain portions of the work. This could include requirements for obtaining the employer approval for subcontracts and ensuring that subcontractors comply with the terms of the main contract. Similar to PWD 203A, PAM 2000 likely includes clauses addressing subcontracting arrangement. This clause may detail the process for selecting subcontractors, the responsibilities of the main contractor in managing subcontract work, and any requirements for the employer's approval or notification of subcontracts. For CIDB 2000 may also contain provision related to subcontracting, satisfying the rights and obligations of the main contractor and subcontractor. This could include requirements for formalizing subcontracts, ensuring that subcontractors meet certain qualifications or standards, and addressing issues such as payment and dispute resolution between parties. So for the case, Williams versus Roffey, Bros and Nichols Contractors Ltd 1991. The applicants Roffey Bros were builders who were contracted to refurbish 27 flats belonging to a housing corporation. The contract has had a penalty clause for late completion. The applicants subcontracted some work to Williams, a carpenter. When Williams fell behind with his work, the applicants offered him bonus payment to finish on time. Williams carried on working until the payment stopped. He sued the applicants for breach of contract. The applicants argued that the agreement to pay extra was unenforceable as Williams had provided no consideration. The appellants only received the practical benefit of avoiding the penalty clause. They did not receive any benefit in law. Williams was only agreed to do what he was already bound to do. So next we will go to clause 48. Clause 48 is defects after completion. The comparison is PWD 2003A likely includes provision regarding defect liability periods, which specify the duration within which the contractor is responsible for rectifying defect that arise after completion. This period may vary but is typically around 12 months. Similar to PWD 203A, PAM 2000 likely includes provision for defect liability periods which stipulate the time frame during which the contractor is responsible for rectifying defect after completion. Like the other standard form mentioned, CIDB 2000 likely include provision addressing defect liability periods, defect notification procedures, and the responsibilities of the parties for rectifying defect after completion. For the case, Hadley Bind and C. Cole Ltd versus Heller and Panthers Ltd 1964. Hadley Bryan were interested in working with East Power and a company they had not previously worked with. So they sought a financial reference from their bank. Heller and Partners provided a satisfactory reference for Easy Power, which turned out to be incorrect and inappropriate. When Hadley Bind suffered losses following non-payment from Easy Power, they sought a claim against Heller and Partners. There was a actionable cause in negligence where there is a special relationship in certain circumstances. This could give rise to a claim for purely economic loss. Special relationship where there is an assumption of responsibility, albeit no contract. From what we can see here, even though these contracts have different names, the content are quite similar to each other. That's all from us. Thank you.
Audio Jungle.